Hello everyone and welcome to this video tutorial on the defence of intoxication. We refer to intoxication as being a defence, but actually intoxication is not a defence to a crime as such, but where a person is intoxicated through drink or drugs and commits a crime, the level of intoxication may be such as to prevent the defendant from forming the necessary mens rea of the crime. The general rule on intoxication is that if a defendant is voluntarily intoxicated and commits a crime, there is no defence. There are some exceptions to this, but as you'd imagine, public policy plays a strong factor in deciding whether the defendant's intoxication may be used by a defendant to negate the mens rea of a crime. It's obviously not in the public interest for criminals to escape liability simply by saying that they were so drunk that they didn't know what they were doing. And in fact, this is often seen as an aggravating factor rather than a mitigating factor, particularly where the defendant put himself in that position in the first place. So the law has formulated various rules of slightly uncertain ambit in seeking to strike the balance between, on the one hand, imposing criminal liability on a party who didn't have the mental element of the crime, but on the other, wanting to protect the public from those who deliberately put themselves in a position where they're unable to control their actions. So for this reason, the law draws rather complicated distinctions between voluntary and involuntary intoxication, and also whether the offence is one of specific or basic intent. And in general, as you'd imagine, the law is generally more accommodating to people who are involuntarily intoxicated, who have not voluntarily put themselves into an intoxicated state. In order to understand the rules on intoxication, we firstly need to understand the difference between specific and basic intent crimes, because the rules on intoxication vary depending on whether the defendant's done a specific or a basic intent offence. Specific intent crimes can only be satisfied through intention. So these are the crimes that don't have recklessness as part of the mens rea. So for example, murder is a specific intent crime because your defendant must intend to kill or intend to cause GBH. There's no recklessness, they've got to have intention. Theft is another specific intent crime because for theft, they've got to have intention to permanently deprive. A basic intent crime, on the other hand, can be satisfied through intention or recklessness. And if you think about the word basic here, an easy way to remember this is that if you think about everyday language, I've heard you students say it, if someone's basic, it means they're common. So basic intent offences are much more common than these generally more serious specific intent crimes because they can be committed through recklessness. And recklessness is a lower level of mens rea than intention. So it's easier to be reckless to take an unjustified risk than it is to develop specific intent. If you think back for a moment to your non-fatal offences against the person, we studied 5 offences there. Assault is basic intent because if you think of the mens rea of assault, it's intentional recklessness as to whether the victim apprehends the infliction of immediate unlawful force. Battery is also basic intent because if you think of the mens rea, it's intention or recklessness as to whether the force is applied. If you think, however, of a Section 18 GBH, that is specific intent. Okay, so for our non-fatals, the first 4 offences are basic intent, and the last one, Section 18, the most serious, is specific intent. So it is vital that you understand the difference between the two, because if in a scenario your defendant is drunk and he's done an assault, you'll need to know, okay, assault's basic, what are my rules on intoxication for basic offences? Now that we've looked at what a specific and a basic intent crime is, I want to show you why that's relevant for intoxication using this summary grid here. So we've got specific intent crimes here. So as I've said, that would include Section 18, GBH, and murder and theft. Basic intent offences are ones like assault, battery, ABH, GBH Section 20. So those are different criminal offences. And then there are two ways that you can be intoxicated. Voluntary intoxication is where the person has volunteered or chosen to get themselves drunk. Whereas involuntary intoxication is where they haven't chosen to get drunk. So, for example, they might have been spiked. And so what the law does here is says that if it's specific and voluntary, he might be able to have intoxication. If it's basic and voluntary, he can never have intoxication as a defence. But if it's involuntary intoxication, it could be a defence to both types of offences, but we have to be sure that they're not able to form the mens rea. So I know this seems quite complicated at the moment, but we'll have a look at some cases on this. But what we're seeing from this grid is that the law is more prepared to accept a defence of intoxication if you've been involuntarily intoxicated, because then it can be a defence to both types of crime. Whereas if you have chosen to get drunk, it's only going to be available for specific intent offences, never for basics. We've seen that summary table and we've got an idea of where we're going with this. Let's have a look at some cases that help to illustrate the points. So we're going to start off by studying voluntary intoxication. So this is where the defendant has chosen to take the intoxicating substance. So they've drunk a load of beer, like Homer here, or they've taken drugs. They have chosen to put themselves in that position. Now we know from our grid, I've just switched back here for a second, we know from this grid that if they are voluntarily intoxicated, it could be a defence to a specific intent crime. And the case that we've got that illustrates this point is a very unpleasant case, actually. It's the case of Sheehan and Moore. And this illustrates the rule on voluntary intoxication and specific intent offences. The facts here were that we had two defendants, Sheehan and Moore, who were very drunk and they'd chosen to get drunk at the pub, so it was voluntary intoxication. And they saw a vagrant and they set fire to him. And the court held that they were too drunk to have formed any intention to kill or cause GBH, and their intoxication was able to be used as a defence. So this case gave us the principle that voluntary intoxication can negate or take away the mens rea for the specific intent offence of murder. Now, I must say, I don't agree with this case, and it has been heavily criticised. To me, I can't understand how, even if they were extremely drunk, how they didn't have the mens rea for GBH at the very least when they set fire to this man. However, the court weren't convinced. So they didn't have the mens rea, they were too drunk to form that. But notice that they were found guilty of manslaughter. And manslaughter is a basic intent offence. And we know, if I flick back to our summary grid, that voluntary intoxication is never a defence for basic crimes such as manslaughter. So what we're seeing from Sheehan and Moore is if they're voluntarily intoxicated and they're so drunk they can't form the mens rea for murder, they'll be not guilty of murder, but we drop it down to manslaughter and then their intoxication is irrelevant here anyway. Another case that we've got on this same point is Lippman, and our defendant here had chosen to take some drugs, some LSD, so he was voluntarily intoxicated. And he was hallucinating and he believed he was being attacked by snakes and descending to the centre of the earth. Now, his girlfriend was shouting at him, presumably for taking drugs, and he thought her shouty mouth was the opening mouth of a snake. So he crammed bed sheets into her mouth, believing she was a snake, and he killed her. Now, his intoxication meant that he couldn't form the mens rea for murder. So because he thought she was a snake, he didn't have intention to kill, and he didn't have intention to do GBH. But, just like we did with Sheehan and Moore, we dropped it down to manslaughter, and because that's a crime of basic intent, his intoxication is irrelevant, so he's guilty of manslaughter rather than murder. So what we're seeing here is that although intoxication is relevant, can be used for murder to negate the mens rea, you're not going to get off scot-free because you're still going to be prosecuted for manslaughter. You need to consider the situation with intoxication and Dutch courage. So where a person forms the intention to commit a crime and then drinks in order to enable them to carry out the crime, i.e. to give them the confidence or the guts to do it, they can't then claim that the intoxication prevented them from forming the mens rea. And that's illustrated in Attorney General and Gallagher, where our defendant decided to kill his wife. He bought a knife to kill her with and also a bottle of whiskey, and he drank a large amount of the whiskey before killing her. And he wasn't able to use his intoxication as a defence because the court said, and this is a really important phrase, drunken intent is still intent. So Dutch courage can't be used as a defence. Consider the situation with voluntary intoxication and basic intent offences then. DPP and Majewski is the most important case on this, and our defendant had taken a mix of alcohol and drugs, and in a pub he was attacking people. And the House of Lords in this case confirmed that voluntary intoxication is not a defence for basic intent crimes. So your assaults, your batteries, your ABH, your GBH20, if you've been voluntarily intoxicated, it is not a defence to those. In the case of Hardy, our defendant set fire to his girlfriend's wardrobe after he'd taken Valium. Now, Valium is a soporific drug, which means that it normally gives the person a sort of sleepy effect. It calms them down. It's a tranquilizer. So our defendant had taken the trank because he wanted to calm himself down. But unfortunately for him, it had the opposite effect to what he was expecting. And what the court said here was, if the defendant takes a drug, the intoxication might be involuntary if it had the opposite effect to what he expected. So in other words, because it's involuntary intoxication, he could use his intoxication as a defence. That's a bit controversial when you compare it to the case of Allen, where the court held that if the defendant mistakes the strength of alcohol, that's still voluntary intoxication. So here this guy was drinking homemade wine, and he said he didn't know it was that strong, and therefore his intoxication should be involuntary because he didn't know how strong the wine was. But you can see for public policy reasons, the courts don't want to accept that argument because otherwise we'd all just be saying, oh, I thought it was non-alcoholic, I thought it was weaker to get away with the crime. So here, if you mistake the strength of alcohol, it is still classed as voluntary intoxication, which means that you won't be able to use it for basic intent offences. Our last case on involuntary intoxication is Kingston, which is extremely controversial, where the defendant was drugged by blackmailers and his victim was also drugged, and he was set up basically to commit a sexual assault. Now, he'd been drugged, spiked, without his knowledge, so it should have been involuntary intoxication, which should have meant that he could have used that as a defence. But the House of Lords still upheld his conviction and said that he had the mens rea despite the involuntary intoxication, so he could be prosecuted for the offence. And we'll end on the summary sheet there, so make sure that you understand the difference between voluntary and involuntary intoxication and offences of basic and specific intent.